Since this whole program is about basically rethinking development, and I have been asked to talk about the judiciary and its role in development. Therefore, in order to understand the role of the judiciary in development, we first need to, it will be useful to have a brief glimpse of the origin and the nature of the judiciary in India. So, the judicial system in India essentially was set up by the British. The system that we are following, it has British origin. When the British government was there, when India was a British colony, at that time they set up this judicial system. We have continued that same judicial system after independence. The main difference after independence was that we adopted a constitution, and in that constitution we created the high courts. Well, there were high courts even before that, but they were mainly appellate courts. Now the high courts and the Supreme Court were made into constitutional courts, and the constitution entrusted an additional function to the high courts and the Supreme Court in particular, which are called the higher courts. So apart from the job of resolving disputes between citizens and the state, between different states, the additional job that was entrusted to the higher judiciary in India was to protect the constitutional or the fundamental rights of citizens, and also to ensure that the other organs of the state, that is the executive and the legislature. I am sure all of you are familiar that broadly there are supposed to be, the state has three organs: the executive, the legislature and the judiciary. So one of the functions entrusted to the judiciary was also to ensure that the other organs of the state function within the bounds of their powers. They do not go beyond the bounds of their powers. And also that because the thinking is that every power is coupled with a duty. That means that if you have the power to do a certain thing, you have the duty also to use that power whenever a situation arises which calls for the exercise of that power. For example, if the police has been given the power to arrest criminals, then when there is a criminal in front of the police, then it is their duty to arrest that criminal, and therefore one of the functions of the judiciary also is to ensure that the executive in particular exercises the powers that have been entrusted to it when a situation arises which clearly calls for the exercise of those powers. However, the general view is that the judiciary cannot compel the legislature to enact any law, etc., because the legislature is a more amorphous body consisting of number of MPs, MLAs, etc., belonging to different political parties who may have different views. It's not a unified body which can be directed to act in a unified way, because it consists of a collection of lots of people. So the legislature cannot be given any direction according to the judicial thinking so far, but the executive can be given directions. So, see, the British created the judiciary in India primarily not really to be as an instrument for justice for the natives of India, for the common people of this country. They created a judiciary which could be entrusted to ensure that a person who violated the law, a criminal so to say, could be tried and sent to jail, could be punished, and also that well-to-do people if they had disputes, they could resolve those disputes through the judicial system. They were not interested, the British, the colonial Raj was not interested in creating a judicial system which would become an instrument of justice for the common people of this country. So this is one thing which we need to understand and recognize. So the whole system is geared towards either ensuring that a person who is caught by the authorities or by the police as a criminal, that he could be tried and punished, or that the well-to-do people, if they have any dispute about property, etc., those disputes could be decided. This was the nature of the judicial system which the British had created. And that is why this system is such that you cannot really use this judicial system, or you cannot even activate this judicial system without the help of lawyers. The procedures are so complicated and technical that only lawyers who understand all those procedures can negotiate their way through this judicial system. An ordinary person, a common person, cannot really access the judicial system without lawyers. Okay, so ये तो इसका origin and the nature of the judicial system. The other thing that the Constitution did was, since one of the major roles of the judiciary would be to keep a check on the use or abuse of powers by the executive and even the legislature. Judiciary has been entrusted with this function of even quashing laws passed by the legislature if they are against the Constitution, if they are unconstitutional, if they are violative of fundamental rights. And the judiciary has further said that even constitutional amendments can also be struck down by the judiciary if they violate the basic structure of the Constitution. So since this is one of the important functions entrusted by the Constitution to the judiciary, it was essential to ensure that the judiciary is independent of the executive and the legislature. In order to make it independent, the Constitution provided a very difficult procedure for taking any action against judges, so that the executive or the legislature could not easily take action against judges. So a very difficult and complex procedure is provided for impeachment and removal of judges. And one of the consequences of that has been that the judiciary, higher judiciary in particular, the High Courts and the Supreme Court, have become virtually unaccountable and therefore not subject to any control. Therefore, the judiciary to some extent has also been abusing their powers because they are virtually unchecked. Now, as many of you would know, that the Constitution has defined certain fundamental rights of citizens, and the most important ones of those fundamental rights are Article 14, which provides for the right to equality, Article 19, which provides for various civil rights like the freedom of speech and expression, the freedom of association, the freedom of movement, the freedom of carrying out your profession. All those freedoms which are called civil rights are enshrined in Article 19. And Article 21 is the right to life and liberty. Now, however, what the Supreme Court has done, because one of the roles of the Supreme Court is also to interpret the Constitution, interpret various laws, etc. The Supreme Court, while interpreting the right to life and liberty, has said that that the right to life and liberty does not merely mean the right to just live and not be killed, or the right to remain out of jail, but it includes the right to have all those things which are necessary to lead a dignified life. So they have said that the right to life includes the right to a fair and reasonable environment. It includes the right to water. It includes the right to food, minimal food. It includes the right to even minimal housing, at least basic housing, etc., or shelter rather, not housing, shelter. So, this is one of the things which was done by the Supreme Court in the early 80s. This was a period when we had judges like Justice Krishna Iyer, Justice Bhagwati in the Supreme Court, who were left liberal judges, left-leaning liberal judges, socialist-minded, and therefore they creatively expanded the Article 21 right into all these things. Thereafter, they also said that they also invented a tool called public interest litigation. And they said that anybody, any citizen or anybody could activate the court for not just their own rights, for not just protecting their own rights, but for enforcing and protecting the rights of either a class of citizens who were underprivileged and deprived, who were not in a position to fight for their rights in the courts, who could not access the courts, etc., or some general rights, for example, the right to a fair environment, which is a right which everybody enjoys. The person who is activating the court or who is approaching the court, he also enjoys those rights. Various other people, all the citizens enjoy those rights. And if those rights are being violated, then any citizen can approach the court for enforcing those rights. The other, another right of that kind is the right to live in a corruption-free society, because corruption has also been held to be something which eventually leads to violation of your right to life, which has been expanded to mean the right to lead a dignified life. Therefore, you could approach the court to check corruption also. If you had some evidence to show that corruption is taking place somewhere and that the authorities are not taking any action on that corruption, you could approach the court, and the court could then direct the authorities to take action, or alternatively sometimes even they have set up special investigating teams or devised innovative ways of investigating and dealing with that kind of corruption. If it was felt that the normal police, which is supposed to investigate and take action, was not in a position to take action because that police is controlled by those very people against whom action needs to be taken, those very ministers control the police, then the courts have sometimes also said that, well, the normal police will not investigate this, but some other special agency or even a special investigating team would be investigating that. Now, now I'm giving you something which is not part of the sort of standard understanding of the judiciary, but which is my own understanding and my own observations of dealing with the judiciary, particularly the higher judiciary. So, one of the things, if you look at how courts have behaved, how the higher judiciary has behaved particularly in public interest cases, when it comes to protecting, if you divide rights broadly as sort of human rights, that is the right to a dignified life or the right to minimal facilities versus environmental rights. So these are two different kinds of rights, and sometimes there is a conflict between these two kinds of rights. For example, there was this case regarding the ridge of Delhi, and the ridge is supposed to be an environmentally important geographical feature of Delhi, and the idea was that the ridge needs to be protected from any kind of development, etc. So, when the issue arose that there are these poor people who are living on the ridge, the Jhuggi dwellers, etc., who do not own that land but who have just occupied that land and are living there, then the courts were very quick to order, the Supreme Court was quick to order the eviction of the people living on that ridge, the poor people living on that ridge, on the ground that it is important to protect the ridge because it's a very sensitive environmental hotspot, so to say. But then when the same question arose, there were certain shopping malls, etc., which started coming up on the ridge, and the question arose as to whether these shopping malls can be allowed to come up on the ridge. Then eventually the courts buckled down and they said, all right, these shopping malls can come up on the ridge. So that shows a kind of class bias of the higher judiciary, of the Supreme Court in this case, against the poor and in favor of the very powerful, wealthy, well-to-do people. Same thing happened, not the same thing, something similar happened when it came to evicting people from forest areas, from reserve forests and from other protected forests, etc. There again, there have been people who have been living in forests for generations, etc. Of course, now there is a Forest Rights Act which has come, which ensures, or which at least says that nobody can be evicted from a forest area until some authority determines as to whether these persons have been living in that forest for generations and therefore have got rights, have acquired rights to live in that forest, and therefore that land rights are conferred upon them. But prior to this Forest Rights Act, there were cases in which the Bombay High Court had ordered the eviction of forest dwellers from forests on the ground that, look, forests need to be protected. The point that I am making is that if you observe the behavior of the higher courts, when there is a apparent clash between environmental rights and basic human rights, that's the right to live, the right to just survive, because if you evict these forest dwelling people from the forests, then their whole survival is threatened. So when it comes to environment versus just the basic human rights, then you find that there is often a tendency of the higher courts to privilege environmental rights over basic human rights. And this is apparent in several cases where, in order to protect these kind of environment from wildlife habitats, etc., people have been ordered to be evicted, etc. These environmental rights, which are about maybe protecting wildlife or protecting forests, etc., in the guise of that, people who have been living in those areas for generations are sometimes ordered to be evicted. But when you examine environmental rights, if they come into conflict with so-called development, however the ruling establishment understands development. So for example, shopping malls are coming up, which is development, or dams have to be made, which is development. Even if those dams are violating the basic human rights of people, that is displacing them from their habitats, or even if they are causing considerable environmental damage, they are violating environmental rights of people. But because dams are perceived to be development, quote unquote development, therefore you usually find, I am not saying that this is the invariable rule, there are always exceptions to this, but in general, the general tendency of the courts is, if there is a development project for which people need to be displaced, for which environmental damage needs to be caused, then that's okay. Same thing happened with interlinking of rivers. Of course, interlinking of rivers is a classic case by itself, where actually that gives you some idea of, though that's not the norm, but it gives you an idea of how whimsically the Supreme Court can function sometimes. So there was this case going on in the Supreme Court about pollution of the Yamuna. In that case, one lawyer who was appointed as the amicus means a person who has been appointed by the court to assist the court, who is supposed to be independent. That lawyer filed an application in that Yamuna pollution case, saying that the President of India at that time, Abdul Kalam, had given some Independence Day speech in which he had said that if rivers in the country were linked up, then that would solve the problem of drought as well as floods. Because the theory was that if all the rivers were linked up, then if there was a flood in a river, you could divert the river of that, the water in that river into another river where there was a drought. So it will solve the problem of flood in this river and solve the problem of drought of another river which has shortage of water. So this was a kind of very simplistic notion which Abdul Kalam mentioned in some Independence Day speech. And this lawyer he is currently the Solicitor General, who was the amicus in that Yamuna pollution case, he filed an application in that case, in the Yamuna pollution case, saying that the President has given a very good idea of interlinking rivers and government is not doing it, and therefore the court should order the government to interlink rivers. On that application, the Supreme Court issued notice to the Government of India and all the states. And this Chief Justice who was there, Kirpal. He was retiring in 4 weeks' time, so he should notice returnable 2 days before his retirement. And on the next day of hearing, only 2 affidavits had been filed, one by the Government of India, one by the state of Tamil Nadu. Government of India said in its affidavit that this is a good idea, this is a jolly good idea, but it will take 43 years to implement this project of interlinking rivers, and it will cost some 6 lakh crores. So, in the state of Tamil Nadu filed a short affidavit and they said that this is a very good idea. So on that basis the Supreme Court passed an order, that Chief Justice Kirpal passed an order in the very next hearing that Government of India has said this, State of Tamil Nadu has said this, we don't think it should take 43 years, we think it should be possible to do it in 10 years time, and 5 lakh or 6 lakh crores is not a big sum of money for this country, and therefore it should be implemented, and he ordered the implementation of this interlinking of rivers. The result of that is that, you see, this interlinking of projects is very sort of simple to think about it, but it's a very, very complex thing. In fact, that order was made about 15 years ago. In the last 15 years, the only progress that has been made on this interlinking of rivers is that they have started work on interlinking one river, Ken with Betwa river, which is in UP and Madhya Pradesh. Ken river and Betwa river. So the idea is to make a canal between these 2 rivers so that water from one river could be. Of course, here there is one project which is called the Beas Satluj Link project, which is a kind of precursor to this interlinking of rivers in a way, where you can divert water from the Beas river into the Satluj river. This project was made about 30-40 years ago. But you see, undertaking even one project like this is a nightmare because it involves all kinds of problems. There is displacement of people because you have to make a dam, you have to make a reservoir, you displace people from there, then you have to make a canal. That canal sometimes goes over hills, etc. Sometimes you have to make tunnels, all kinds of, sometimes you have to pump up the water. It's a construction nightmare, it's a social nightmare, it's an environmental nightmare because forests may be submerged, forests will have to be cut, the canal will have to go through lands of people, all kinds of problems, and it's a hugely expensive and difficult thing to do. And without thinking about any of these things, you just order the government. Actually, in fact, there had been, this thing was floated earlier, about 50-60 years ago. It was examined at that time. There was one engineer called K.L. Rao who had floated it, then it was examined, then it was found to be unfeasible, etc. And it's stupid also for the reason that in India, during the monsoon, when one river is in flood, other rivers are also in flood. It's not as if there is drought in one river or in the neighboring river and there is flood in another river and so on. So therefore, that's also not going to help much. But anyway, Supreme Court. So this shows they were not bothered, I mean, quite apart from the sort of imperial and casual manner in which such a huge decision is taken. But apart from that, it shows that they had very little concern about the human rights of people who were going to be displaced by these projects, about the environmental rights of people, about the consequences for the environment, just because they thought that this is good for development, this is good for business and so on. You see, unfortunately, this notion of development, which has been propagated by the ruling establishment in this country for the last several decades. The notion is that anything which results in GDP growth is development. So ultimately, actually Praveen must have talked about all this. Development has been equated with GDP growth. So you don't look at other things. You don't look at equity, who is benefiting from this GDP growth. You don't look at and who is losing in this process. You don't look at environmental consequences or environmental costs that is taken to be free, even if you are causing enormous damage to the environment, even if your activity is leading to climate change, which is going to be catastrophic, not just for us but for everybody on the earth. Even that we don't factor into the cost, nor do we factor in intergenerational equity. So if, for example, if that GDP growth is derived from using our oil, using our other mineral resources, which are accumulations of centuries of millions of years, and you are consuming all of that in the space of 100 years or 200 years, and you are going to leave nothing for future generations, quite apart from the environmental damage that you are causing. Of course, in the case of using oil, you are also causing climate change. But even if you are not causing climate change, etc., but you are just consuming those resources over a period of 100, 200 years and not leaving anything for future generations, then that's totally inequitable, it's totally unfair, it's totally irresponsible. So those things are not factored in at all. And unfortunately, the judiciary, being composed of, or the class composition of the judiciary is similar to the class composition of the general ruling establishment in the country. The same kind of, that means if you look at the IAS officers or the top officials in the country, of course the politicians are slightly different. They come from a slightly different class because sometimes the politicians come from a not so wealthy or well-to-do class of people, but they quickly imbibe the same kind of thinking and characteristics as the rest of the ruling establishment, that is, those who control large corporations, and eventually it's really the corporations the large corporations of the large vested interests who come to influence or control the politicians also. So the thinking becomes the same. Anything which promotes GDP, actually that's somewhat simplistic and facile way in which they have made us look at development. They say कि well, GDP growth, why is that not development? After all, if wealth is produced, if wealth is created, that wealth will eventually trickle down and benefit everybody. So that's development. What's wrong with that? GDP. So that's the simple explanation that they give. But basically, what is driving is those large corporations who have come to influence and control the ruling establishment in this country, that their commercial interests are what is really driving this model of development. So long as their profits can increase by any kind of activity, whether it is by building dams, interlinking rivers, or nuclear power plant. Nuclear power is another good example actually. This was a recent judgment of the Supreme Court arising out of this Kudankulam project in Tamil Nadu. You see, this project, nuclear power, is today quite apart from the fact that it's the most expensive way of generating electricity. If you generate electricity from a coal powered thermal plant, the electricity cost may be 3 rupees a unit, let's say. If you generate electricity from a hydroelectric plant like the one that you saw yesterday, that electricity may cost 4 rupees a unit. If you generate electricity from let's say a gas based power plant, that may also cost about 4 rupees a unit. If you generate electricity on an average, I am saying, maybe there may be some difference on the basis of project location, etc., but by and large this is the average. If you generate electricity from wind, it may cost 5 rupees or 6 rupees a unit. If you generate electricity from solar cells, it may cost today 6 to 7 rupees or 8 rupees a unit. If you generate electricity from nuclear energy today, it costs even more than that. It costs even more than generating electricity from solar energy, from wind energy, from coal. You can say that there are external costs to generating electricity from coal because there is global warming, carbon emissions and so on. Hydroelectric projects, there are other kinds of costs. You might have been told about that. There are sometimes, of course, in these kind of projects there is not much displacement, but there are other environmental costs, that part of the river almost dries up, that river ecology is affected in that region. There is also environmental damage caused to the hills due to the construction. The hills become fragile. For example, that catastrophe in Uttarakhand in Kedarnath, that was also the extent of that catastrophe was greatly accentuated or increased by all these hydel projects that had come up. In fact, Ravi Chopra authored that report. He might have spoken about it during his, he was chairing that expert committee which was appointed by the Ministry of Environment to look at the impacts of these hydel projects in Uttarakhand. So, these have various external costs, but still the cost of generating electricity from all these sources is less than the cost of generating electricity from nuclear, because nuclear, the capital cost is very high. But apart from that, you see, nuclear has two other very, very, very serious problems. One is that in case you have an accident and there is as happened in Fukushima in Japan, or as happened in Chernobyl in Russia, or as nearly happened in 3 Mile Island in the US, the consequences of one accident are so horrendous, because that whole region becomes uninhabitable for many, many, many years. You lose that land, you can't do agriculture in that land, everybody has to move out of that area, thousands of square miles of area has to be just cleared out. People suffer from cancer for many generations and so on and so forth. So that's one very serious problem. The other is that nobody has yet found a safe way of disposing of nuclear spent fuel. because the nuclear material that is used as fuel, after it is exhausted for the purpose of this producing electricity, it still remains radioactive for literally thousands of years. And therefore you need to find a safe way of storing that. And nobody in the world has so far been able to find a safe way of storing nuclear fuel. But yet nuclear power plants were built. Of course, now they are not being built anymore in most of the countries. The advanced countries like the US, Germany, Italy, Japan, they are now phasing out or dismantling their nuclear power plants. But in India, we are still embarked upon an ambitious program for expanding nuclear energy. So this case of Kudankulam came up, where one of the major issues was safety, because there were very serious problems of safety, all kinds of problems of safety. If there was, because it is at a coast, if there is a tsunami that could cause an accident like in Fukushima, therefore, and yet the Supreme Court, if you look at that judgment, that proceeds on the basis that nuclear energy is good for development, we have to produce more electricity, nuclear energy is fine, and therefore we have to suffer all these costs, etc. That is the risk of an accident, the problem of not finding a way of storing the spent fuel, etc. So that also reflects the same kind of understanding. So what emerges from all this is three propositions that I would like to place before you. One is that while the Supreme Court has been very proactive and good in expanding the definition and understanding of fundamental rights and human rights by expanding Article 21, but they have not shown the same kind of alacrity in enforcing those rights. For example, I didn't mention that, I should have mentioned it actually, that they declared that the right to shelter is a fundamental right. Now, the Government of India, fortunately, when VP Singh was the Prime Minister, they made a policy about these Jhuggi dwellers in Delhi, which said that those people living in Jhuggis on government land, in these temporary hutments on government land, that they will not be removed or displaced unless that land is required for some important public purpose. And even when they are removed, they will be rehabilitated in some other way, in some other place. So they actually divided the Jhuggis into three categories. Those which are on land which is not going to be required ever for any public purpose. There the policy was that they will be settled on the same site, which means that their Jhuggis and the land would be regularized, and proper civic amenities, the planning of that area would be improved, proper civic amenities would be provided to those people. Second was those which are on land which is not right now required for any immediate public purpose, but which may conceivably be required at some future time for some public purpose. There, for the time being, proper civic amenities would be provided, electricity, water, some roads, sanitation, this would be provided. And eventually, if that land is required, they would be removed, but they would be then rehabilitated somewhere else. And the third was those which are on land which is immediately required for some public purpose, those people would be removed but would be rehabilitated somewhere else. Now, this policy of the government is completely consistent with the court's own declaration that the right to life includes the right to shelter. But when it comes to, I've been dealing with a lot of these cases in the High Court and also in the Supreme Court. When these authorities displace and remove these jhuggi dwellers without rehabilitating them, without giving them any alternative land, etc., then very often you have to move the court and the court doesn't respond at all to their petitions. And this is despite the fact that displacement or their removal without rehabilitation is not only a violation of their right to life, it's a violation of the government's own declared policy. So one proposition is that the higher courts and the Supreme Court has been very good at expanding and declaring, has been quite proactive in expanding and declaring the rights of people, but has not been so good or proactive in enforcing the same rights which they have themselves declared. Second proposition is that when there is a conflict between basic human rights and environmental rights, the higher courts seem to give a preference to environmental rights over basic human rights. The third proposition is that when it comes to a conflict between human rights and environmental rights on the one hand versus so-called development, which means this kind of GDP growth-led development, then the courts seem to prefer development over human rights or environmental rights. These are some broad propositions. However, of course, the courts have despite all this, the higher courts in this country have still proved to be a useful instrument to protect citizens against abuse of executive power or even against legislative power on several occasions. The court, the higher courts, the Supreme Court and the High Court have protected environmental rights fairly proactively in many cases. On many occasions, there is a permanent forest bench in the Supreme Court. It was also on the orders of the Supreme Court that this Green Tribunal has been created. And they have also more recently, they have been somewhat active on issues of corruption, against abuse of civil rights and civil liberties of people. The courts have been less proactive than they ought to have been, because during the emergency, for example, when this issue arose as to whether people can be just picked up and put in jail without any reason, on just some stated apprehension that that these people are a threat to internal security, etc. The courts said that during an emergency, all these fundamental rights are suspended. Therefore, the right to even move the court against illegal detention is suspended. So that was a sort of major failure on the part of the courts to protect civil rights and civil liberties of people. Recently, for example, they have done something useful, which is striking down 66A. So the record of the court in protecting civil rights and liberties is uneven, on the whole not very good. For example, this TADA, which is a totally black law which in my view, is totally unconstitutional. It gives all kinds of unreasonable powers on the police authorities to catch hold of and put people in jail, etc. That law was upheld by the Supreme Court. It should have been struck down as being unconstitutional, violative of fundamental rights, etc. But on occasions they have given good judgments also, because, for example, Vinayak Sen was charged with sedition. There have been, in Kudankulam, all those protesters, more than 1,000 of them have been charged with sedition. The Supreme Court, as far back as in 1962, held that the charge of sedition cannot be laid against any person unless he has incited people to violence or has incited people to public disorder. You can't say that merely because he has created disaffection against the state that will lay him open to a charge of sedition. So, at least on some occasions, the court has protected citizens from the violations of the state or of state authorities. So, broadly this is the picture of the judiciary and how they have looked. I mean, this is a sort of very broad overview. One can get into more detail. So I'll end here.